If a federal statute is administered by an administrative agency, it's arguable that the agency, which has domain expertise, is in a better position than courts to interpret statutory ambiguities. That understanding has led to a rule of judicial deference known as the Chevron doctrine. In Michigan v. Environmental Protection Agency, we explore that doctrine and its limits. Amendments to the Federal Clean Air Act in 1990 established the National Emission Standards for Hazardous Air Pollutants Program, which targeted certain sources of hazardous air pollutants for regulation by the Environmental Protection Agency, or EPA. With regard to fossil fuel-based power plants, the Act instructed the EPA to study the public health risks posed by power plant emissions, and only regulate power plants if the study showed that regulation was, quote, appropriate and necessary, unquote. The EPA interpreted the statutory appropriate and necessary directive as not requiring consideration of costs. After conducting its study, the EPA determined that power plant regulation was both appropriate and necessary, and power plants were therefore subject to regulation under the Hazardous Air Pollutants Program. An impact analysis showed that regulation was expected to cost power plants $9.6 billion per year, while yielding benefits valued at only $4 to $6 million per year. Various parties, including 23 states, filed suit against the EPA, challenging its conclusion that it wasn't required to consider costs when determining if regulation was appropriate and necessary. The D.C. Circuit upheld the EPA's decision, and the United States Supreme Court granted cert.